Your Honor, I just want to say thank you for your judgment. I thought long and hard of what I was going to say to you. And the Lord told me just tell you the truth. My lawyer warned me. I have to tell you.
Okay.
I did use my hands and said, baby, stop. She was pregnant. I didn't understand how hormones work. I was trying to rationalize it for her. I didn't understand. She was walking it out the house 2 a.m. I follow her with the car, come home, what are you doing? She doesn't even understand what was going on with her. And I held her hands and I told her to stop. Please, that's really in my heart. That's what happened that day. And I was out of frustration. But that's putting my knee into someone's stomach, shaking a baby, doing all this other stuff. I wasn't even built like that to do something like that. It's not in my nature. I was raised well by a parent that loves me very much. I don't want to shoot my child that same love. I just don't want to go to jail. I'll take 12 years probation. I don't care. I just want to be with my kid and provide for him. And that's been my heart the whole time. I helped too many people too fast, and I didn't understand the weight of life.
A courtroom in San Antonio, Texas. A Friday morning in late spring 2026. Judge Renee Munoz is on the bench in what appears to be a veterans treatment court docket. The room is moving fast. Cases are being called, reset, sentenced, and closed one after another. A court reporter named Cindy sits at her station. An attorney asks for a 2-week continuance on a harassment charge. The judge grants it.
Court is calling 2026 CR 000623, State versus Kristen Clark. Can I have parties announce?
Roger Fettis for Mr. Clark, Your Honor.
And are you Mr. Clark?
Yes, Your Honor.
All right, the court took evidence yesterday from the complainant. The court is going to sentence you to 6 years deferred adjudication.
Someone mentions allergies and a garden. The mood is routine. Then case number 2026 CR 000623 is called. The defendant's name is Kristen Clark. He is a veteran. He is standing before a judge who has already heard testimony from the woman he hurt. The judge read the facts. The judge sat with them overnight. Now it is Friday morning and the judge is going to sentence him. The charge carries an affirmative finding of family violence.
There's an affirmative finding of family violence. There's to be 300 hours of community service restitution. I'm going to order parenting classes. Once parenting classes are completed, 100 hours will be deemed satisfied of the community service restitution. I'm going to order the BIPP course. Once that's completed, 100 hours will be deemed satisfied.
That is a legal designation that follows a person permanently. It strips the right to own or possess a firearm under federal law. It can affect employment, housing, and custody. It cannot be expunged. When a judge makes that finding, they are not just closing a case. They are attaching a permanent legal marker to a human life. The judge sentences Kristen Clark to 6 years deferred adjudication. Deferred adjudication means the defendant pleads guilty or no contest, and if he successfully completes all the conditions of supervision, the conviction is never formally entered on his record. He does not go to prison today, but the family violence finding is entered regardless. That stays.
No, Your Honor. I'm renting rooms in my house to try to generate income. Right now, the felony is stopping me from getting like a decent job. I could only work at construction, but under the table, I'll try to like get some money some other way. But right now, I'm not working for a job. I've gotten 3 job offers, but after the record, they see the felony. They told me no.
The conditions are substantial. A $1,500 fine, 300 hours of community service, a battering intervention and prevention program course known as BIP, parenting classes, a substance abuse evaluation, regular reporting to a probation officer, field visits to his home once per month for 3 months. No contact with the complainant. Then the defendant speaks. He says the Lord told him to tell the truth. He says his lawyer warned him. He says what happened was that his pregnant partner was walking out of the house at 2 a.m, and he grabbed her hands and told her to stop. He says he does not understand how pregnancy hormones work. He says he was out of frustration. He says he is not the kind of person who puts a knee into someone's stomach or shakes a baby. He says he wants to be with his child. He says he will take 12 years probation. He says he just does not want to go to jail. The judge listens. The judge does not challenge the account directly. The judge notes that the family had too many people living in one house, that the defendant was the sole breadwinner, that the complainant's relatives kept moving in, and that the financial stress was real.
All right, so what do we want to do with this no contact order? Because she came in, she wants contact with him. It appears to the court, and if I'm wrong, somebody please correct me. It appears to me that one, of course, it's never okay to put your hands on anyone in anger, but it appears that there were a lot of people in the household, many of them the complainant's relative, and of course, a child that he has with her and one that's on the way. And he was the sole breadwinner, and people, his wife's family, people just kept moving into the household. And so it appears that there was financial stress going on here. And
the judge says it is never okay to put your hands on anyone in anger, and then the judge moves on. The defendant mentions the VA. He mentions that when conflict would escalate at home, he would leave and call 911 himself and ask to be taken to the emergency room rather than get into a fight. He says he has a video of the state of the house. He says he showed it to his parents.
I don't think that's relevant, but I have a video on my house when I came back from the VA, because usually I would leave to go take care of myself instead of getting conflict with her. I would call 911, they would come pick me up and take me to the emergency room. And I would deal because it's that deep. Anyways, I took a video of the house. I showed it to my parents, and that's why they bailed me, because they understood when they saw the video, they understood. They was like, whoa. If they couldn't, I couldn't even believe it. I had to show other people because they think that I'm in the wrong for who I was. And I am in the wrong. No one should act like that.
He says he starts school the next day through a VA vocational rehabilitation program. He has a 1 o'clock appointment already scheduled to access veterans' resources.
Starting school tomorrow, well, with the VRNE, the VA's help me go back to school for electricity.
Okay.
So that I'm gonna be going to school. I don't know, because you mentioned full-time job. I'm thinking how I'm gonna go to school full-time and do that. And
okay.
The state had asked for no contact with the complainant. The complainant herself had come to court the previous day and said she wanted contact with the defendant. The judge notes that there has already been informal contact, that the defendant helped her find her own apartment, that he gave her money toward it, and that there is a child together and another child on the way. The judge modifies the order. Instead of no contact, the order becomes no harmful or injurious contact.
No, Your Honor. I assisted her to get her own place when I got out. Luckily, I was able to get out to help her to find a place. We chose together, and I gave her half the money. Her parents put $300 and got her a place, so she's comfortable.
With field visits every 2 weeks until the defendant...
All right. Then there'll be no harmful or injurious contact with the complainant. And there's going to be field visits. Once every 2 weeks until 2 classes of BIP are completed. And then following that, field visits 1 time per month for 3 months.
Completes 2 BIP classes. After that, monthly visits for 3 months. The case comes back in 60 days for a status check. The judge explains what no harmful or injurious contact means.
You know what that means? That means 1, you cannot, one, of course, no touching inappropriately with violence. You understand?
Yes, sir.
And also, it means that there is no degrading someone in words or in deed.
Yes, sir.
You should have a loving household, okay?
And record of this after the complainant be available.
The judge says it means no touching with violence. It also means no degrading someone in words or in deed. The judge says the household should be loving. The next case is called immediately. A man named Pierce Jones. He is also at sentencing. His mother is the complaining witness. She is a physician. She left early because she was scheduled to perform surgery. She signed an affidavit before leaving asking for no harmful or injurious contact rather than a full no contact order. She wants to help her son find a boarding home.
His mother, Judge, is his support system. She is listed as the complaining witness in the case. She was here earlier, and she was trying to stay. However, she was scheduled for surgery. She's a physician. She was scheduled for surgery, but I have been working with her, and she has represented to me that she's going to help find a place for him to live in terms of a boarding home. He's helped her stay at boarding homes. My clients stay at boarding homes before, such as Rio's boarding home, things of that nature. So that is his support system to help them find a place to reside and be compliant with things, Judge. And she was here, and she expressed to me her apologies to the court that she did have to go, but she did execute this affidavit, Your Honor, with regard to contact.
Any objection?
Where she's wishing for a no harmful injurious contact for the fact that they're not going to be residing or living together, but she's going to help coordinate him with
The mental health evaluation had flagged significant issues. The judge skips community service entirely in this case. The judge says the real issue is mental health.
Ms. Abrams, I'm not going to do community service hours in this case because I think the real issue.
3 years deferred adjudication. Intensive outpatient supervision. A status check in 60 days. No residing with the complainant. No unsupervised contact with minors. Between cases,
All right, so this is what I'm going to do. I'm going to sentence you to 3 years deferred adjudication. There's to be no residing with the complainant, and there's to be no harmful or injurious contact with the complainant. There's to be regular reporting by Zoom or in person, regular UAs, proof of employment or SSI within 60 days. There's to be no employment as a home health care provider or with minors. There's an affirmative finding of family violence. There's to be field visits 1 time per month for 4 months.
the judge and the attorneys talk about a court reporter they once knew who was not actually transcribing anything. No one knew for years. They only found out when a defense attorney finally asked for a read.
You know how lately you've had people who are supposed to be sign language interpreters and it's all messed up? Do you know there was a case where they had a court reporter who really wasn't taking anything down? Yes. And you Google it, and you know how they found out about it? Because it was all over the news. How they found out about it was somebody wanted something read back. Out of all the trials she did, nobody ever asked. Then finally somebody's like, could we have that read back? And they're like, hey. Yeah. So I always test Cindy. I'm like, can you read that back for us? Cindy, people were threatening to, Vashon, Monica, they were saying they were going to come over there and type for you. I said, I was the one who was saying no.
Back. The judge says she tests her own court reporter regularly. Everyone laughs. It is Friday. There is a detail in the Clark sentencing that does not announce itself. The judge is actively trying to help the defendant navigate costs. The BIP course costs around $305 total.
All right. I think there is a parenting course that's free.
They have different ones, Judge.
All right. So with regards to the parenting, see if there's one that costs less.
Well, we'll give him a referral, Judge, and he can, we give him a list and he can do that research.
Okay. And if you look into it, I know there are some parenting classes that are free, because when I go to different CLE courses, there are people who give me things and say, hey, this is a free class. Please consider this free class. And before you leave here today, and Vashon, before he leaves here today, I'm going to check, because I know I just received an email from somebody about parenting classes and something else. I think I may have sent it to you.
The parenting classes are approximately $125. The judge knows there are free parenting classes available because people hand her flyers at continuing legal education courses. She says she will check her email before the defendant leaves the building. She says to let him access VA resources for the parenting requirement. She says once 2 BIP classes are completed, the defendant can come back and she will consider lifting the no-contact order entirely. The same judge who entered a permanent family violence finding, the same judge who imposed 300 hours of community service and banned possession of any firearm for life, spent time on the bench trying to find the defendant a free parenting class. That tension is not a contradiction. It is the architecture of a system that is trying to hold two things at once: accountability and continuation. The family violence finding cannot be undone.
To appeal. Because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question about that, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. So you need to wait in court so that probation can go over conditions with you, and so that someone for the Veterans Treatment Court can give you different resources. And if you're thinking about going to school, I think veterans, they have some programs, and sometimes people don't take advantage of those programs. So hopefully you will take advantage of that.
Yes, Your Honor, that's planned today. I have actually an appointment at 1 o'clock with them. I'm
Okay.
excited.
The weapons prohibition is permanent and federal, but the judge is also looking at a veteran who called 911 on himself to avoid escalation, who helped his pregnant partner secure housing, who has a 1 o'clock appointment to access education benefits, and who told a courtroom that the Lord told him to tell the truth.
Yes, Your Honor, that's planned today. I have actually an appointment at 1 o'clock with them. I'm
Okay.
excited.
All right. Well, thank you for your service.
Thank you for your support.
All right. You're welcome. Thank you. All right.
The judge is deciding how much structure to build around that person and how much space to leave for something to grow. What happens in rooms like this one every Friday morning in every county courthouse in the country is not news. It does not go viral. There is no verdict. There is no dramatic outcome. There is a judge working through a docket, modifying conditions, looking up free classes, asking probation officers what they think, and trying to calculate, with imperfect information, whether a person is likely to hurt someone again. The permanent record is being written. The weights being placed on the scale today will not be removed. That is what accountability looks like when it is not being performed for anyone.